Hi and welcome everyone. Thanks for joining us for this timely and important panel discussion today focused on voting rights. With millions of Americans already voting in this year's election, which of course has presidential candidates, but also 35 Senate seats, 435 House seats, 11 governor seats, 10 attorneys general seats, and over 350 state supreme and appellate court seats. The stakes for protecting voting rights this year are very high. I'm Felicia Lynn, and I'm the Dean of Students here at the University of Pennsylvania Carey Law School. And I'm delighted to have this group of voting rights experts to talk about advocacy, both past and current, and what the pandemic means for this particular election. Before I introduce our moderator, a few housekeeping points for you. You can submit a question for our panelists using the Q&A function that you can find in the ribbon at the bottom of your window. It's active now, so you can use it when you have questions, and we'll try to address it during the Q&A. Please keep your questions topical and appropriate. And we're recording this webinar for those that can't attend later. So with that, I will introduce our moderator for today's panel, Jason Abel. Jason is currently a partner in the DC office of Steptoe & Johnson, where he chairs the firm's campaign finance and political law practice. His work focuses on election security, election administration, and regulatory compliance with federal election law. He is also the former chief counsel to the U.S. Senate Committee on Rules and Administration. And most importantly, Jason is a 2003 graduate of Penn Law School. Jason, thanks very much for joining us.
Thank you, Dean Lynn, and the rest of the Penn Law community for organizing this timely and important panel today, which is part of the school's year-long Achieving Racial Justice conversation. I'm honored to be part of it and look forward to an informative and insightful discussion. In April of this year, Justice Ruth Bader Ginsburg, dissenting in RNC v. DNC, stated, "Either they, the voters, will have to brave the polls, endangering their own and others' safety, or they will lose their right to vote through no fault of their own. That is a matter of utmost importance to the constitutional rights of Wisconsin citizens, the integrity of the state's election process, and in this most extraordinary time, the health of the nation." We are now less than 2 weeks until November 3rd, hard to believe, I know, and over 30 million Americans have already cast their ballots. We are all participants in an unparalleled election cycle during an unprecedented year, one marked by a global pandemic, uncertainty at the Supreme Court, the loss of civil rights heroes such as John Lewis, and a refusal by this administration to agree to abide by the results of the elections, thus throwing a peaceful prospective transition in doubt. These new challenges are layered on top of pre-existing obstacles to the franchise, made more onerous by the Supreme Court's opinion in Shelby County v. Holder, which, in invalidating the Voting Rights Act Section 4 coverage formula, removed the protections afforded to voters by Section 5 preclearance. With the backdrop of the most important election of our lifetimes conducted amidst the pandemic, we are honored to have 3 brilliant and forceful advocates join us today. Now, we only have an hour, as these folks' day jobs are, needless to say, extremely hectic, especially this time of year, and we are grateful for their time today. My introductions will not do their important careers justice. First on our panel, we have Deuel Ross, Senior Counsel at the NAACP Legal Defense and Educational Fund. At LDF, Deuel is counsel in a variety of voting rights and school desegregation cases and lead counsel in the challenge to Alabama's photo ID law. He has played a significant role in the fight for voting rights, representing Black voters in challenges to discriminatory state and municipal election laws. Deuel is also part of the Penn Law family, having graduated in 2009 before going to clerk for Judge Roger Gregory on the U.S. Court of Appeals for the Fourth Circuit. He also teaches a seminar on voting rights here at the law school. Next, we are joined by Blair Bowie, legal counsel and Restore Your Vote manager at the Campaign Legal Center. As part of CLC, Blair's work addresses felony disenfranchisement laws and financial barriers to restoring voting rights. Blair is a 2017 graduate of Penn Law, where she was a Toll Public Interest Scholar, was granted the Dean Jefferson B. Fordham Human Rights Award, and founded the Democracy Law Project and served as president of the Lambda Law Chapter. Finally, we are pleased to be joined by Ben Jealous, President of People for the American Way. Ben has been a leader in advocating for social justice, police accountability, and voting rights for decades, having served as the former national president and CEO of the NAACP, the former executive director of the National Newspapers Publishers Association, and as the Democratic nominee for governor of Maryland. Ben is a distinguished visiting fellow at Penn this year as well. He started his fight for justice as a community organizer, and those efforts and values are still evident in his work today. So the way this will work is I'll turn it over to each of our panelists for some comments, but please, as Dean Lynn said, use the Q&A function. This is your opportunity to ask these experts questions about the election, about voting rights and the franchise. So we hope to have a pretty engaging discussion today. Deuel, I'll turn it over to you first.
Sure. Thank you, Jason, and thank you to the Penn Law community for inviting me. I'm so glad to be on this panel with such great, fighters in the fight for voting rights and civil rights in America. I think everyone has heard, if not from the media, but from other folks, that this is probably one of the most important elections, certainly in a lot of our lifetimes. We really have a lot of really disturbing things going on at the national level and also at the local level. And the result of, the COVID-19 pandemic and the real upturn in the number of people who are trying to suppress the vote ahead of this election, particularly after, as Jason noted, the end of the pre-clearance regime of the Voting Rights Act with the Shelby County decision in 2013. We've seen sort of an explosion of litigation around sort of the right to vote and COVID-19 and the ability of people to vote both absentee and in person. We've seen something like 300 cases being filed across the country, including cases in Pennsylvania, dealing with the ability of people to vote absentee, the ability of people to vote in person safely amid the pandemic. And we've also seen a response by states to basically, take these cases from the lower courts to the Supreme Court, and seen the Supreme Court unfortunately intervene in some of the cases that Jason mentioned, like in Wisconsin. So I will sort of very briefly summarize what some of that litigation has looked like, including my own. So as a senior counsel at the Legal Defense Fund, I've represented Black voters in cases in Alabama, Arkansas, Louisiana, and also in an amicus brief in a Texas case, and then also some Black voters in South Carolina, all challenging sort of the lack of no excuse absentee voting in these states. And then also in Alabama, the lack of curbside voting, in Louisiana, the lack of expansive early voting. And all of these cases are sort of, the idea is to make sure that people have the opportunity to vote without having to go in person and potentially expose themselves to a deadly virus. The results of the litigation, to sort of summarize it, have been mixed, both in terms of my own litigation and the litigation of other folks. What you've seen is that in Alabama, for example, we went to trial, spent 2 weeks proving that Alabama's strict photo ID requirement for absentee voting violated the Constitution and the Americans with Disabilities Act. That Alabama also has a requirement that in order to vote absentee, you have to have 2 witnesses sign your absentee ballot. And so thinking about that in the context of the pandemic, if you're someone who lives alone or is high risk, having to go out in the middle of a pandemic and find 2 people who you do not normally come in contact with exposes you to the danger of potentially becoming infected yourself. And then also in Alabama, the state's Secretary of State has prohibited local jurisdictions from offering curbside voting, even though that is, there's no prohibition in curbside voting in Alabama law. And so, that's sort of the kinds of things that we're dealing with and seeing in the voting rights sphere. The sort of the number of these kinds of cases that have been filed are dealing with those types of things. In Pennsylvania, I think, just for those who are probably heard about the Supreme Court decision recently, in Pennsylvania, there had been state court litigation about extending the absentee ballot request deadline. And for whatever reason, the Republican Party took that case that had been fully litigated in state court up to the United States Supreme Court, arguing that the extension of the absentee ballot submission deadline was violated federal law. And the Supreme Court split 4-4 just this past week, basically declining to get involved, but that doesn't mean that they cannot or will not get involved later on. And so, I say all this to say that we're really worried about not just the ability of people to cast a vote, but also the ability of the court systems to sort of work in the way in which they're meant to, which is to protect people's rights within the context both of a pandemic and outside the context of the pandemic. And I'm happy to sort of answer more questions about those cases specifically. But I think one thing just for students to be thinking about, and folks in the Penn law community, because you all, I'm sure, are very much aware that you're in a wing state, those of you who are still in Pennsylvania, being active in your community is one way in which you can sort of help address the kinds of things that we deal with through litigation. I'm sure Blair and Ben will talk a lot more about. But just keep in mind that there are things that you can do that don't necessarily involve filing a lawsuit, because that's not always as effective as one would want it to be. And that is just volunteering to be a poll worker on election day. A lot of law students obviously do not fall into over 65 category, which is what most of our poll workers are. And so to the extent people are interested in doing that, they should go and sign up at powerthepolls.org. And to the extent people want to use their law degree outside of just being a poll worker, sign up for 866-OUR-VOTE, which is the election protection voting hotline that LDF and other organizations use on election day, but also before election day, to sort of monitor the polls and find out what things are going on, and also to provide voters with basic information and assistance. So with that, I will turn it over to Blair, and then happy to answer questions about litigation or other things folks can do ahead of the election.
All right, thanks so much, Deuel. Thanks, Jason and Penn Law, for having me here today. It's great to be back. And I'm really honored to be on this particular panel. Yeah, Deuel, the work that LDF has been doing has been really incredible across the country to expand access to the ballot in this really unprecedented election. I think there's, broadly, there's a lot of uncertainty. There's a lot of good guys fighting for expanding access and updating some of these laws that aren't designed to deal with vote by mail being the primary means of casting a ballot. And there are also a lot of bad guys on the other side trying to make it more difficult for people to vote, trying to keep votes from counting. So there's a lot of uncertainty. The thing that I want to focus on in this little opening spiel is a ray of sunlight, which is that in this presidential election, we are going to see hundreds of thousands, possibly close to 1 million people casting their ballot for the first time, who are people who were formerly disenfranchised because of felony convictions. The road to get here in the last 4 years has been a little bit rocky, particularly in Florida. So put a pin in that. I'll talk a little bit more about what's happening in Florida. But a lot of national attention has focused on Florida and kind of missed the fact that a handful, like more than half a dozen other states, have expanded the franchise to folks with past felony convictions in the last 2 years, and even more if you're looking back to 2016, and you'll have a lot of people who got their rights restored then who will still be participating for the first time in this presidential year. So that's really exciting, I think, for a number of reasons. The main reason is that felony disenfranchisement in this country is a racist tool. It was designed as a tool of white supremacy, and it continues to have a disparate impact on the Black population and on other people of color. We saw the Sentencing Project put out a report this year that for the first time counted the numbers of Latinx people who are disenfranchised, and sort of captured the disproportionate impact on that community as well. Felony disenfranchisement technically has its roots in some common law theories, but America is the only common law country that still disenfranchises people even after they've completed their sentence. So don't be fooled by that. The real reason we have felony disenfranchisement across the country is because it became a useful mechanism to silence Black voters after the Civil War. And that's when you really see the proliferation of these laws that are still on the books now all across the country, not just in the South. So we're finally getting to a point where we can see the light at the end of the tunnel of eradicating felony disenfranchisement. And that is a really big deal for our country generally. It also, I think, is a big deal in terms of fighting for criminal justice reform. As the criminal justice system has expanded, we've also seen the voices of the people who are most impacted by that system being shut out of our democracy, and those are very related phenomenon. So I'm really excited to see these hundreds of thousands of newly empowered voters contribute to what will undoubtedly be record high participation in this election. And also for that group to really start to flex its muscles as a counterbalance to the endlessly expanding criminal justice system in this country. And so that's like what's really exciting about it. I think what's challenging about this is that even as access to the ballot box has been expanded for people with felony convictions, there's been major backlash and barriers for folks to actually cast their ballots. In our organization and sort of the project that I run at Campaign Legal Center is called Restore Your Vote, and we focus specifically on providing direct services to people with past convictions to figure out if they can vote and help them break down any barriers that are keeping them from actually casting their ballot. And what we see is that a lot of election administrators don't understand how these laws are supposed to work. So a lot of people still, even though they technically have the right to vote, are wrongly denied because of their past felony convictions. We've seen that a lot in Alabama. In 2017, Alabama passed a law that re-enfranchised over 200,000 people. And even in the months leading up to this election, we've documented many problems where registrars are wrongly denying people who clearly have the right to vote. And that's just because the state hasn't done a good job of educating the registrars about how the law is supposed to work, and that's deliberate. So this is sort of gets at the first concern I have is passive voter suppression, which happens when statewide officials don't adequately explain the law to registrars. Or just don't check to make sure that registrars are doing things correctly. So those registrars, even in states that have expanded the franchise, may continue to disenfranchise people who have past convictions, but because they're just doing what they've always done, or because they're acting maliciously. So that's a problem that I think we're going to see, and we're keeping a close eye on for Election Day. And then you have Florida, which is sort of the poster child for this backlash. The voters of Florida overwhelmingly approved a constitutional amendment that made clear that Floridians wanted people who had past felony convictions to be able to come back into the franchise and vote again and be full members of society after they've completed their sentence. And then the legislation, that was the largest expansion of the franchise since women were granted the right to vote. But what we saw is the legislature didn't want that, so they made it so that folks would still have to pay off their fines, fees, and restitution in order to vote, which rolled back an expansion of the franchise of roughly 1.4 million people. It took out about 900,000 of those people by some estimates. And Florida, this is going to be an ongoing issue in Florida. One thing that I'm concerned about is right now, even after the poll books have technically closed in Florida, the Secretary of State is trying to purge people from the voter rolls who are registered and challenging people for owing fines and fees, even though it's prolonged litigation has shown that the state is really bad at knowing whether or not people owe fines and fees. So I think even through Election Day and after Election Day, we're probably going to see a lot of fighting over whose votes should and shouldn't count in Florida. So I'll leave it there and hand it over to Ben.
Thank you, Blair. Blair talked about the racist origins of ex-felon disenfranchisement. 118 years ago, there was a constitutional convention in Virginia. State Senator Glass, who would go on to be U.S. Senator Glass and Treasury of the Secretary, under Woodrow Wilson, that Klan member who became president. And you would know his name from the Glass-Steagall Act. But when he was a young politician, he stood up at the 1901-1902 State Constitutional Convention in Virginia to put forward five voter reforms, one of which was a lifetime ban of formerly incarcerated people voting. And when he closed the argument, making it clear that people like my grandmother's grandfather, who was a state senator in Virginia during Reconstruction, and my grandfather's great-grandfather, who was in the first class of blacks in the Virginia legislature, once his reforms would pass, would never be able to be elected again. Specifically, he said that they would assure white supremacy would be the law of the land in every county of Virginia. That white supremacy would be the law of the land in every county of Virginia. That was his closing argument for the lifetime ban of formerly incarcerated people voting. The strength to fight it on the left has often wavered. Tim Kaine himself refused when I was president of the NAACP to restore the voting rights, calling himself a civil rights lawyer, to restore the voting rights of formerly incarcerated people in Virginia as governor on his way out the door to become chairman of the DNC. Think about that for a second. There was actually a Republican governor who followed him, who we got to do more than any governor ever had, just simply because he had the conviction that people had a right to redemption and therefore a right for their voting rights to be restored. That was Bob McDonnell. When you go back, to understand where we are now, you have to understand like kind of where things started after the Civil War, and a context in which women did not have the right to vote. Frederick Douglass gave his most impassioned speech right in the post-Civil War period, maybe the most important, right after the 14th Amendment was passed. The speech was called Our Composite Nationality. It was his tirade against the Chinese Exclusion Act. The attacks on immigrants of color and on Black folks' voting rights have always been twin attacks. And the white supremacy behind them always clear. The senators who pushed through the Chinese Exclusion Act in response to the native birth provision of the 14th Amendment argued that the white man would have no place to buy a home in California if we did not forcibly expel the Chinese, going so far as to send their bones back to China. Chinese Americans. That's why when Martin Luther King pushed through the Civil Rights Act, the second order of business was ending the Europe-only preference for migration to this country. And that was the second thing that the coalition did. So the fight that we're seeing right now to suppress the Black vote and to suppress the votes of immigrants of color, it's been going on for a decade. A rise of the Tea Party and the Latino Exclusion Acts that we saw in states from Alabama to Arizona back in the right as voter ID was rising in 2010 and 2012. Has been part of a conservative effort for more than a century to suppress the vote. And why? Each of those arguments back then were about demographics. And what the conservative movement has been clear about is that demographics are not in their favor. Donald Trump has said quite plainly, if more people vote, it's not good for Republicans. Now, what we forget in all of this, and the kind of gender attack on the vote that was barring women from voting, and the racist attack that's been the efforts to bar Blacks and people of color, is that men who did not own land were barred from voting after the revolution as well. There's been a general sort of antipathy to the poor voting in large numbers as well. And it's all kind of tangled together. Now, why should we have hope in this moment? And, for that, I would go back, and I'll just offer you, this is my grandma. This is my Black grandmother. She graduated from Penn in 1953. From the School of Social Work. She commuted up on the trains from West Baltimore, where she had just moved out of the housing projects, where she raised my mom along with my grandfather. In the artful words of a critical race theorist, my grandmother's body as a Confederate monument. She descends from Thomas Jefferson's grandmother by her other slaves that were her grandchildren, by her other grandchildren that were her slaves, rather. And it was her grandfather who was the last in our family to serve as a Reconstruction statesman. Well, my grandmother would tell you, living on the balcony of history as she does, she's a 104-year-old retired social worker who trained Barbara Mikulski to be a social worker, right? She carries with her 100 years of history she's seen and another 100 that she inherited from her grandparents and great-grandparents who were born slaves. And so when she looks into the future, she actually looks further than most, both because she's a Southerner, but also just because of where she lives, if you will, in her head. She would tell you that what is happening in America as far as voter suppression is exactly what you would expect to see when the white supremacists who gave us the Chinese Exclusion Act and the white supremacists who gave us the lifetime ban on formerly incarcerated people understood that they were within a quarter century of losing their demographic advantage, of white supremacy ending as the OS of American democracy. You would expect the conservatives to lurch way to the right and act like a fox backed into a corner. Well, my grandma was first and foremost a Virginia farm girl. And she would tell you that, you don't fear the darkness, that you wake up in the darkness to start for the day, knowing that the dawn is coming. And she would also tell you that when you're dealing with a fox backed into a corner, you just finish the job. You don't get put off or scared by the fox lashing out. Fox are usually kind of mischievous, kind little creatures. They're bad to mice, but not to people. But when they're backed into the corner, they become this vicious thing, kind of like the GOP has right now. But it's the fear that the fox displays in its viciousness that confirms that the fox understands that everything's about to change and it's not going to be good for the fox. And so as an organizer, somebody who cut my teeth as an organizer of the NAACP legal defense when I was 18 years old on high-impact civil rights cases, what I would say is this: we lean into the moment. We understand that the opportunity for civil rights litigators, for organizers, for activists, for citizens, the great opportunity of being an American has always been this: small groups of us can make a better future come faster for the rest of us. And as dark as these times are, we wake up in the darkness. We don't fear it. We simply work for the dawn, knowing that we can literally make the sun rise faster through our work. So I would encourage all of you these next couple of weeks, if you're concerned about where things are headed in our country, remember, Bill Clinton missed a lot of classes his first year at Yale Law School and still managed to become president. You got more time to volunteer these next couple of weeks than you probably think. Go out and do it because we can make a better future come faster. And what's happening in our country is in the way that, politics is a lot like physics. What we're seeing, is for every action, there's an equal and opposite reaction. But the difference here, like my grandmother said, is that ultimately the sun's going to rise. Their demographic advantage is going to fall apart. The Koch brothers can't hold off the future forever. They simply want to hold it off until they die. And I, for one, would like to see them have to reckon with an America where finally all of us are included. Thank you.
Thanks, Ben, and thank you to Blair and to Deuel. One of the consistent themes I think that we're all going to be talking about is what you all can do to really understand the landscape and then to get involved. One of the questions that a couple of our viewers have asked relate to mail-in ballots. This is a cycle where many folks that are used to going and voting in person are now, for a variety of reasons, voting absentee, COVID being probably the biggest reason. And watching the news or following it online, you see that there are a variety of different administrative requirements per state. In Pennsylvania, we're hearing a lot about naked ballots. In North Carolina, we're hearing a lot about signature matches. These are requirements that appear to be sort of neutral on their face. But when you dive down, you see that they do appear to have a disproportionate impact on certain communities. I believe Black voters in North Carolina have had their votes being put aside due to signature match more than other voters. I'm wondering if you all could put this in context a little bit in terms of what these administrative, quote unquote, administrative requests actually pose to voters and how they might be somewhat in a long line. Ben, you had mentioned this, Blair, you had mentioned this as well, sort of a long line of other obstacles to the franchise. Whoever wants to jump in first.
Yeah, I mean, I'll say a little something about it, which is to say, I think there are, as I mentioned, there's a lot of the litigation has been around this very issue, right? Has been, who is allowed to vote absentee. So in a lot of states, you're not allowed to vote absentee unless you have an excuse. Those states that require you to have sort of a narrow range of excuses in order to vote absentee, which is mail-in voting, are primarily in the South. And I think that is not surprising given the history of the South and being a place where, you have to jump through hoops in order to do any kind of voting. But I also think, when you're looking at a place like Pennsylvania, even that has, rules related to kind of how your absentee ballot needs to be submitted, I think all of this comes from, a hesitancy to embrace mail-in voting. There are only a handful of states, primarily in the West, that allow basically conduct all of their elections by mail. And I think most states are sort of very, suspicious of the absentee voting process. And I think, that comes out in the context of how they process absentee ballots from, like I said, having these requirements that you have to have a particular excuse in order to vote by mail, or having to make people jump through additional hoops, like in North Carolina, having to have a witness sign your absentee ballot, and then also having to have your absentee ballot signature be matched with the signature that's on file in the state. I think these requirements, particularly in those states that I've worked in, you can trace them to a history of racial discrimination. In our Alabama case, where we were challenging the two witness requirement, the court actually found that when the legislature passed the two witness requirement for absentee voting and limited the number of people who could vote absentee, that was in part a product of intentional racial discrimination, right? And so these things, obviously, in a place like Alabama and a lot of places, people usually don't vote absentee that much, and so it doesn't affect that a large number of people. But now, because of the increase in the number of people who want to vote absentee given the pandemic, you're seeing things that are sort of normally affect 3 or 4 or 5 or 10% of voters and still have a disproportionately racial impact are now affecting, 20, 30, 40% of the people who are trying to vote absentee and avoid crowded places because of COVID-19. So, unfortunately, I think that some of these restrictions on absentee voting are a product of, trying to get the system right, but a lot of them are a product of sort of the racist history of restricting voting access, particularly in the South.
And I'll add on to that too, that both when it gets down to it in a court of law and sort of in the court of public opinion, it really helps those who want to suppress the vote for our country to have sort of a myopia about like, what are the reasons that we have all of these rules and regulations? It should be enough, like Deuel and Ben have pointed out, that a lot of these laws that are still on the books have openly racist origins and that they continue to have a disparate impact. But if you get down to the point in the analysis where you're looking at, okay, well, what is the state's reason for this anyway? And is that legitimate or is it rational? We have such blinders on. Like, most democracies don't even have voter registration. North Dakota doesn't even have voter registration. Why do we even need that barrier in the first place? Colorado for years has been conducting elections totally by mail. Australia has a universal requirement that everyone vote. Like, look beyond the myopia of why we've built these requirements up and the sort of proffered and phony interests that are being given for what we know to be laws that are just about voter suppression and are, from a practical perspective, totally unnecessary to a well-functioning democracy.
Yeah, you know, I think it's important when you're winning the case in the court of public opinion, which truly does matter if you want to try to win in a federal court in a big civil rights victory, to pay attention to the class angle and the gender angle in addition to the race angle, because you ultimately need to speak to the self-interest. Politics is about self-interest of as many voters as possible. And while lawyers often focus on disproportionality, there's all sorts of reasons, you know, relating to litigation strategies for that. It sometimes misses the full point with the public. I'll give you an example. When we were fighting voter ID in Pennsylvania, the folks were very quick to talk about racial disproportionality, but when we dug into it, really all three of the traditions of American voter suppression came right to the surface: race, gender, class. It turned out that voter ID was going to sort of most numerically impact working women who are disproportionately likely to vote Democratic. It also came just the fact that it was going to impact on working people in general. And you have to remember that the bias for American voting isn't just for whites to vote or for white men to vote, but for rich white men to vote. Every time you walk by Carpenter's Hall in Philadelphia, consider this. Carpenter's Hall was where the populists gathered during the American Revolution. Those were the people most likely to be privates in the Revolutionary Army. When the revolution was done, not one private got the right to vote, because if you owned land, you had the commission to be an officer. And if you didn't own land, you were a private. And so when you're talking about it, and it was ultimately our poster children in fighting voter ID in Pennsylvania became a bunch of Catholic nuns, kind of old white women who had taken the vow of poverty and, you know, didn't carry identification and all sorts of things. And so that's what I said, just, you know, think about when you're kind of fighting these things, really make sure that you look at the race lens and you look at the class lens, you look at the gender lens, you understand all of the impacts. And regardless of the argument in the court of law, you understand the court of opinion. If you can bring all those arguments, it'll be easier to frankly win legislatively, but also to pressure that judge in the way that federal judges, for example, do tend to pay attention to public opinion.
Yeah, thanks, Ben. And let's leave it right there with federal judges. Let's talk about some of this litigation that's actually working its way up to the justices. There's been a couple questions as to the recent Pennsylvania case, where there were 4 justices that were willing to take on this case. There's also been a couple questions related to the Supreme Court's jurisprudence in general, related to the unwillingness to resolve some questions in favor of the voter based on maybe the Purcell principle or other ideas. And wondering whether you all could sort of look ahead, right? We have a possible 9th justice, Justice Barrett, joining the court relatively soon. And wondering if you all would be willing, I don't want to stir up trouble here, but be willing to speculate how the Supreme Court might involve itself or resolve these particular issues that might work its way up to the court. Uh-oh, nobody wants to go first.
No one wants to go first.
I made a mistake with that question, I guess.
No, I'll say just a little something about it, which is to say, you know, I think the Supreme Court, I'll start with Purcell, which is, for those who don't know, is a Supreme Court decision from 2006, where the case came up in a really strange procedural posture and dealing with a district court had denied a preliminary injunction against a proof of citizenship requirement. The Ninth Circuit had blocked that requirement, and the Supreme Court said, it's too close to an election. We don't even know why the district court issued an opinion or it decided to not block this ruling, and the Ninth Circuit shouldn't have stepped in. But the Supreme Court has used that sort of idiosyncratic opinion from 14 years ago to say that anytime a federal court intervenes in elections too close to the election, that they are going to basically block relief on behalf of voters. And what that has meant practically, just speaking from my own personal experience, is that in Alabama and South Carolina, where we had won injunctions against these witness requirements for absentee voting and also some other related requirements, the Supreme Court stepped in both instances and basically blocked any sort of relief for voters. And unlike a lot of other cases, like any other normal case, the Supreme Court sort of did it on its what's called sort of colloquially the Shadow Docket, which is the Supreme Court just issued sort of 1 or 2 sentence opinion saying we are blocking this without any sort of explanation. And that has really created an issue, particularly in the context of the pandemic, because how could you have known a year ago or 6 months ago that this was going to be an issue? And so what you're seeing happening is the Supreme Court stepping in, even when you win in the district court or win in the Court of Appeals, the Supreme Court stepping in and saying, it's too late for voters to get any kind of relief. And I think, again, just to briefly touch on the Pennsylvania case, that case is so unique and incredible because there really are no federal issues whatsoever. And so the idea that the Supreme Court would get involved is really just, terrifying. And the fact that the court right now is split 4-4, with the possible addition of another justice, who knows what that split could look like. And I think that is, the president and others have been quite.
With Amy Coney Barrett, but
Yeah, I would just say the president and others have been quite explicit about why they think there need to be 9 justices, despite the hesitation to fill that seat back in 2016 when a seat was open. And so, I think a lot of folks are gearing up for a Bish v. Gore type of litigation part 2, and the Supreme Court is playing a role in elections right now, and potentially will if the elections are close enough and there are issues that come up after November 3rd.
Thanks, Deuel. So this is somewhat a lightning round question, but we've raised a lot of issues so far on this panel, a lot of obstacles, a lot of barriers to the franchise. This particular cycle, what is the number one issue that keeps you up at night, wakes you up early in the morning, that you think could pose the biggest problem?
I mean, we do the court of law, but QAnon is scary. And it's far from, Facebook and Twitter and the actions that they've taken. You've got at least 5 million people in the country who subscribe to it. They believe things that we believe, most people who pride themselves in rational thought think are farcical. But what it comes down to is, they believe Donald Trump is waging a secret war against Hillary and a band of pedophile cannibals engaged in sex trafficking. It builds on the Pizzagate conspiracy, which of course resulted in somebody shooting through the window of my nephew's favorite pizza shop in Northwest DC. And, when you dehumanize your opposition and you say that they're threatening the welfare of children, you give yourself the opportunity to commit frankly, to commit massacres. It was the issue at Ruby Ridge, at Waco, and in Philly with the move bombing. And so we at People 4, who maintain an operation called Right Wing Watch, but in a lot of conversations that have to do with the fact that the president's refusal to disavow them, the fact that there's a QAnon candidate coming into Congress, and frankly, the dynamic that's been created there's a lot of unknowns about what a crisis, post-election crisis could look like. But the possibility for extreme violence, at least in some flashpoints around the country, is pretty high.
And I think to tie that to voting rights directly, that the certain people's reluctance to change their minds about something that they've already accepted to be true, even when it was totally false, is going to be a big problem, I think, with election day and post-election day litigation, if and when that happens around ballot counting and what ballots should and shouldn't be counted. I think it's going to be made worse by the fact that every state's laws are so different in terms of how absentee ballots go, who can vote after a felony conviction. There's so many different points where a bad actor can say, well, all of these invalid votes were cast. And I think we've already seen in Pennsylvania the groundwork being laid for this. Just to take an example, you had this big scandal around 7 Trump ballots being thrown out. And so this sort of got blown up and was investigated and was pushed by the Republican Party, which supports the requirement that you put the ballot inside a secrecy envelope for the record. And they said, these were 7 Trump ballots, and put out a big press release about it. And then it turns out on investigation, more like 4 of them were for Trump and 3 of them were for Biden. And actually the reason that they were thrown out was because they were naked. And so they had tried to make this big deal about this is like an example of registrars that are deliberately tossing out military ballots for Trump, whatever. And it turned out to not be true at all, but the damage has already been done. When they make that statement, and people are not going to change their minds. They're still going to believe that registrars in Pennsylvania are throwing away Trump ballots. Similarly, this luckily was a failed effort, but the legislature was trying to create a special committee that would have had subpoena powers to collect evidence around voter fraud in Pennsylvania, which would have then, maybe drummed up 4 cases that could possibly look like voter fraud. They would make a big deal about those cases and sow doubt about the results of the election. And that, again, can be debunked. But the problem is, and the problem with sort of QAnon culture is that once it's been put out there, it can't be put back in the box. And so that's my big fear around election day. And I think similar to Ben, I have concerns about where that could lead.
Yeah, I'll just echo everyone's concern. I think the biggest thing I worry about is, violence on election day. And that can be violence of people actually getting hurt to people just showing up with guns, just quote unquote, right? Anything that sort of raises the temperature in what is already sort of a very intense period in American history, as we all know. But, people getting hurt on election day, that's sort of something that we haven't seen in recent American history, although has been sort of highlighted, it has been a part of American history for a long time. But that's the big thing that keeps me up at night.
So let's shift gears a little bit. Dream scenario. You have the ability to push voting reform, election reform, what it might be on a federal level, state level. What type of reform should be pushed? And the other part of that question is what type of reform do you think would take place if there is maybe a new administration and a new Congress in place? I know there was a question about, why isn't there just a standardized ballot? Or why are we dealing with a variety of different state laws here with respect to federal elections? So that was one person's idea, I believe. But what would be your push, and what do you think that a new Congress and a new administration would push should that happen?
Look, if we take back the Senate, the Democrats take back the Senate and the White House, then I think there's a lot that'll be on the table. Right now, there's a bill called H.R. 1 that's an omnibus bill for a bunch of democratic reforms related to getting money out of politics, et cetera. that's worth looking at. That'll come back very much to the fore. Also, you'll see a push for what is now HR 51, which is DC statehood, and HR 4, which is the John Lewis Voting Rights Restoration Act to restore Section 5. All of those will come up as big priorities. You'll also see separately, depending on what happens in various states, a push to get the rest of the states necessary for us to pass the national popular vote, which is a compact of states, to give all of their electoral votes to the winner of the national popular vote. So finally, candidates have to compete in every state. Of course, the Republicans, I think 6 out of 7 of the last Republican presidents, I believe, or elections rather, that they've won, they've failed to win the popular vote. So there you go.
Yeah, I think Ben's absolutely right. I think one thing I just would highlight in what he said is the Voting Rights Advancement Act, which would restore the Section 5 preclearance provisions of the Voting Rights Act, is incredibly important. Right now, the reason why states are allowed to sort of pass any kind of bill or law that they want is because they're no longer subject to preclearance, and the federal courts have sort of thrown up their hands. So restoring the ability of the Department of Justice and putting the burden back on the states to stop these laws before they go into effect is incredibly important.
And I would add too that the restoration of the Voting Rights Act should include eradication of felony disenfranchisement, which was left out of the earlier version of the Voting Rights Act, the original version of the Voting Rights Act, and that the record for passage of the updated Voting Rights Act needs to be so dense and so impermeable that it can't possibly be thrown out by the Supreme Court as going beyond the powers of the enforcement clause.
Great, thank you. So I know we're coming up on 1:30, and I know many of you have class at 1:30. So I wouldn't be a loyal adjunct faculty member if I didn't if I made you guys late. So just want to thank everyone for their time today. The panelists were fantastic, and I think we all learned a lot from their remarks, and I think they were able to really place our current battles in some historical context there, which is very important. In closing, I just wanted to share some guidance from John Lewis. For those of you that may be asking, what can we do? And I know that each of our fantastic panelists brought up some ideas. John Lewis had said something in August of 2019. He was receiving an award from the American Bar Association, which has law students as well. And he said, we need the law to be on the side of the people. We need members of the bar more than ever to find a way to get in the way, to get in good trouble, necessary trouble. I would add that this applies to law students as well. It's definitely not too late to get involved. Vote, volunteer as a poll worker, volunteer for poll observing or voter protection at these organizations that Blair, Ben, and Deuel represent. I don't believe there is any effort that's too small here. So thank you again to our panelists, and hope to see everyone again in Philadelphia very soon. So thanks everyone, really appreciate it.